Today we are going to examine some evidence in the alleged suicide of Jeffrey Epstein. This is a transcript of a hearing after his death, which occurred on August 9th or August 10th of 2019. You will see Martin Weinberg, the attorney for Jeffrey Epstein, speaking of the alleged suicide of Jeffrey Epstein. So I'm going to scroll, bear with me. I'm going to scroll down to page 20 of this hearing transcript, and we will read about how he had concerns about the death of his client, Jeffrey Epstein. I'll start with line 24. Second, in terms, we have a profound problem with the conclusions of the medical examiner. There are for 3 reasons, Your Honor. One is the timing of Mr. Epstein's demise. It was on August 10th. On August 12th, a bail pending appeal motion was being filed in the Second Circuit. Right. On August 12th or 13th, the United States attorneys are going to respond to our request for the preservation and production of documents that would have facilitated and furthered our efforts to demonstrate communications between the Southern District of Florida, the Northern District of Georgia, which was standing in the shoes of the Southern District of Florida Main Justice, and the Southern District. Hold on. In other words, we were beginning the process discharging our responsibilities. There had been no evidence that Mr. Epstein had committed any offense against a minor after 2005. The subject matter of the New York prosecution was squarely within the heartland of the Florida NPA. We had a significant motion to dismiss. This is not a futile, defeatist attitude. Third, we had all the discovery motions that Your Honor had scheduled. So the timing for a pretrial detainee to commit suicide on August 10th, when his bail pending appeal motion is being filed on August 12th, strikes us as implausible. Second, we had an independent doctor who was present at the autopsy, which occurred on August 11th. On August 11th, the city medical examiner's findings were inconclusive. We are told by a very experienced forensic pathologist that the broken bones in Mr. Epstein's neck, in his larynx, are more consistent with external pressure, with strangulation, with homicide, if you will, than with suicide. It doesn't exclude suicide, but the pure medical forensic evidence creates profound issues about what happened to him. Also, at the time of his death, our medical examiner's opinion, it occurred at least 45 minutes, probably hours, before 6:30 a.m. on August 10th, when he was first found. If you will, according to the reports, yet he was moved, something that is not ordinary in these circumstances. I would also, and then the court says, excuse me, he was moved. And then Mr. Weinberg says, instead of having the cell in the condition it was found, if he had been dead for 45 minutes or 2 hours or 4 hours, there were efforts to move him and therefore make it more difficult to reconstruct whether or not he died of suicide or some other cause. I spoke to Stacy Richmond, who is a responsible member of the court who represents the family of Mr. Epstein. She spoke to the medical examiner on Friday after Mr. Epstein's death and asked why, if the conclusion was made late in the afternoon on Friday that week. She specifically asked what the extrinsic non-medical evidence caused the medical examiner to go from uncertain to suicide, and she was told that the medical examiner had seen 9 minutes of a video which was in the stairwell between floors at the MCC. She was told that the principal video that would have showed the whole hall was corrupted. It was in DC with the FBI to see if they can reconstruct it. Also, I asked the same questions that my co-counsel did. Was the dysfunction of the critical pivotal video in the most secure prison east of Florence, out in Colorado, known to have MCC before August 10th, or was this corruption occurring on August 10th, which would again cause us to be skeptical of the certitude of the medical examiner's conclusions that this was suicide rather than some other cause. So with my co-counsel, we ask Your Honor, if it is not a question of trust or not trust, they ask you to detain people and you trust the Bureau of Prisons. And it is within your inherent authority, Your Honor, to find out what happened to our client. We are angry about the conditions he was held in. And we are angry, quite frankly, Your Honor, that the only source of information that we get as to what happened to him is through the media rather than through the United States Attorney's Office. We've made requests informal. We've made TOTI requests. We've been told there is a pending investigation. But we trust Your Honor and the judiciary, with all due respect, that we believe there is an inherent and central role, a pivotal role in your honor to find out what happened to a defendant in a case before this court. Whether or not the court grants the noli pros today, or whether it holds or pending investigation into Mr. Epstein's death. We are not here without significant doubts regarding the conclusions of suicide. We are not here to say what happened. We don't know what happened, but we deeply want to know what happened to our client. Thank you, sir.